Madam Clerk, will you call the next case, please?
Raymond T. Throckmorton III et al. Versus Stephen L. Lefkovitz et al.
And for the appellant?
Good afternoon, Your Honors. May I reserve 3 minutes for rebuttal, please?
You may.
May it please the Court. My name is Michael Braun, and I represent your appellants, the plaintiffs down below, Raymond Throckmorton, Susan Evans, and Terrence McNabb. They are lawyers here in the Nashville area. We are here today to answer some important questions. One of which is, how do we hold an attorney accountable for a tort when he violates the law over and over and over again? For this case, it'll be important to distinguish the two relationships: my client's relationship with their former client, who we call the Wolks, and their relationship with Mr. Lefkovitz, the defendant in our action. One thing I would like you to consider this. Is this a lawsuit that's motivated by the greed of the attorneys? I mean, after all, they received $350,000 for their work in the case. However, consider that they were pragmatists. They settled their case with the Wolks when the opportunity presented itself. They took a case that was an orphan, where the clients had no money to pay for fees. They bore all the risk. This was a case that was not settled. It had to go to trial. And at trial, afterwards, it was appealed. The fact that they were being pragmatists does not make them whole legally or anecdotally, nor does it grant leave for a lawyer to take a meritless case for purposes of, and I won't say it as crudely as Mr. Lefkovitz, of taking and depriving my clients of their property, their fee. There are legal ways that you can take property. I thought of one: the pretermitted spouse who exercises an elective share. She takes from otherwise beneficiaries under a will, but she does it legally. Here, though, it was by all, certainly by our view, it was stolen. And it was something that Mr. Lefkovitz said that he was going to do before it happened.
Counsel, was there a business relationship that was in existence anymore at the time that Mr. Lefkovitz became involved in this? Wasn't the business relationship already done here once the client, I don't think I should have to pay that, I don't want to pay that, I'm going to go see if I can find an attorney? Isn't the business relationship at that point at an end?
I think that's a very good question. I would say this, though, is the contract existed between the parties, and until such time as money would hit the table, and I'm about to talk about when that would be, but when money would hit the table, at that point in time, was Mr. Wolk going to pay the fee or not? There's certainly...
Could your client, though, ethically continue to maintain a business relationship with regard? I mean, once the client says, I don't think I owe you that, I don't think that's disputed, I'm going to go talk to an attorney, and we have a serious professionalism problem if there is a continuing business relationship between your clients and between your clients and their clients with regard to this property dispute.
And that's a very good distinction to make, because you are correct. They could no longer call themselves the Wolk's lawyers. However, they had a contract, a binding contract, a contract that the Wolks are later going to say was a legitimately enforceable legal contract. So while they could not have the professional relationship, that was severed, the contractual relationship still existed.
The upshot of the argument here, as I see it, is that a legitimate contract was undone by an illegitimate bankruptcy case. But the bankruptcy, no one moved to dismiss the bankruptcy case. It seemed like to me, based on the briefing here, that I would have thought, well, gosh, there was all sorts of grounds to dismiss this bankruptcy case so that your clients didn't have to deal with it at all, but that didn't happen.
So, Your Honor, that would go back to how I'm explaining that they were pragmatists. However, let's don't misunderstand what happened at the bankruptcy court level. And the audio from the 341 meeting is in the record. The trustee and my client's attorney were putting the Walks and Mr. Lefkovitz under attack for the way the schedules were done, the manner of behavior, the question of whether or not he had even gotten his client's permission to file the bankruptcy. These are not things that we wrote later. This is in the 341 audio.
I mean, to me, that seems like an almost slam dunk dismissal in bankruptcy. If you get the clients to concede at the median creditors that we never authorized the filing of the petition, that case is over. I mean, there's not a bankruptcy judge in the country that's going to say, well, you know what, I know they didn't authorize the petition, but they're going to stay in. I mean, it's done, right?
So that I agree, but it says two things. One is when the chancellor refers to the bankruptcy as being viable, it wasn't viable. But more importantly, to your question, is they had an opportunity at a court-ordered mediation where $350,000 was presented. Now, at some point, you can call it pragmatist, you can call it good business, but that's an extraordinary sum that's worth settling and not having the bankruptcy dismissed. We could go into conjecture and ask ourselves, if the case had not reached a mediated settlement, would there have been a motion to dismiss? Well, there was. The trustee actually filed a motion to dismiss the bankruptcy.
And this is the U.S. trustee?
The U.S., yeah.
Okay, was a trustee wasn't appointed in the Chapter 11 case?
Well, you're going to tax my knowledge of what Chapter 11, who the various players are. I understood it to be the U.S. trustee. Okay. But I could stand to be corrected.
When the settlement was entered and agreed upon, did all parties agree upon the settlement?
My clients reached an agreement with their former clients, the Walks. Mr. Lefkovitz was not a party to that agreement, and the agreement specifically was not a general release. And the language in the settlement, which, getting the opportunity to tell you again, stated that it was a valid and enforceable agreement. This is important, if I may move on. It took me a while to understand why it was so important for the defendants in this case to obscure and otherwise make the word recovery sound vague and ambiguous. I don't think on first blush most people would see it that way. And we know it wasn't, and there's a fact in the record that tells you it wasn't vague or ambiguous. Because when the chancellor in the underlying case entered his final order, giving the property back to the Walks, at that very same time, they entered into a contract to sell it. So at the same moment they were awarded the property was monetized. It had a number to it. So even the best argument that it was vague, it had a number associated with it. It was not vague. It was not undefinable. But here's why it's important to them that you buy into that. Because if it's not vague, and if we can't identify it, their defense ceases to exist. Think about it. If it's identifiable, then and we couple it with the statement that they made in the settlement that it was a legally enforceable agreement, then there was a breach when prior to that, one didn't exist. There's no other way to put those two things together. They had a valid enforceable agreement. It was identifiable. they didn't pay what was on the paper. A couple more points about the term recovery. The absence in the defendant's brief of any description of what they say it means. You won't find it in the record below. You won't find it in your briefing, what they say it means, or what they say it wasn't. They cite for you the case of Silva, which was a discussion of how to interpret attorney fees agreements. If you even went down that trail and looked at the circumstances and the business and the surrounding transactions and what the parties placed on the contract, you would still have to agree it was a percentage, and 40% was never in question. It was going to be a percentage of the recovery, which was defined at the time that the recovery was made. I'll add something else that's important here, and that is that the Chancellor's opinion is insufficient as it relates to saying that the bankruptcy was legal or viable, but to refer to what happened as discrepancies or deficiencies is not correct. Some of them were criminally prosecutable. Many of the actions that were taken by Mr. Lefkovitz were not things that were in the pleadings. These were things, there's a video. Mr. Walk walked into the Chancery Court on video, and this is in the record, and he says on video that he doesn't know that the bankruptcy has even been filed and that he didn't want to file bankruptcy. Now, piece that together with the fact that Mr. Lefkovitz can never produce his signature. He's tells you that, yes, this is wrongful conduct beyond what I might say in a pleading and say, well, you know, he stinks, he's a bad guy, he's a wife beater, whatever the case might be. That stuff, granted, it can be incorrect, a judge can deal with it. That stuff may be protected by the litigation privilege, but the conduct and the intention to cheat them out of their money, that's not litigation privilege protected material. I see I have 30 seconds left. I do want to speak more to the litigation privilege, and I'll do that on my rebuttal, unless you have some more questions now.
I hear none, thank you. Yes, sir, the appellee.
Good afternoon, Your Honors. My name is Jonathan Cole, and I'm here on behalf of Steve Lefkovitz and his law firm, the Lefkovitz firm. So this is a case involving lawyers on both sides of the equation here. As we submitted to the trial court, and as the trial court correctly found, that there is no cause of action that was stated under any of the theories that were asserted by the plaintiff attorneys in the lower court. And even if they did, the litigation privilege would preclude any recovery. It covers any type of action that was taken by Mr. Lefkovitz. I won't go in detail about the facts, but just to kind of note a few issues for the court. There was a lot of discussion below at the trial court level, and it's in the record, about this attorney fee provision that the plaintiffs' appellants had with their clients, the Wolks. And it was vague. It talked about a recovery. 40% was not at issue. However, it just referred to a recovery of what was obtained in the case. The theories that were presented in the underlying case sought both money damages and equitable relief. The plaintiff attorneys were able to recover and obtain a judgment on behalf of their client just under the equitable relief. That was the only thing that was given in the original case. There were no money damages awarded. And so hence the problem about the vagueness of the term recovery in their attorney fee agreement between the Wolks and the plaintiff attorneys. And there's discussion about that ample below, and the parties negotiated that and what that meant. And when they got to bankruptcy court, they jointly moved the court. They weren't ordered by the court. They were jointly moved the court to be sent to a judicial settlement conference. And from there, the Wolks being represented by, at that point, by Mr. Lefkovitz and his law firm, and the plaintiffs being represented by Paul Jennings from Bass, Berry & Sims, worked out a resolution of a claim of over $500,000, and they'd be paid $350,000 from that. If they had any concern at the time about any issues about how the bankruptcy was pled or presented to the court, or whether or not it was legitimate at all, they could have raised that at that time, but they didn't. They took advantage of the proceeding and made that agreement to take that settlement, presented to the court a joint motion to approve that settlement, and that motion was approved. And so that settlement was approved, and they took their $350,000 and then came back and sued Mr. Lefkovitz and his firm later for what they contend was the remaining balance. They never raised any issue in the bankruptcy court about any concerns about how much Mr. Lefkovitz was paid, or how he was paid, or how the bankruptcy petition was signed, or whether or not the debtors were interested in bankruptcy. None of those issues are raised whatsoever to the bankruptcy court. And as the trial court in this matter that ruled on it found that the plaintiffs should have asserted that, should have taken those issues up with the bankruptcy court when they had the chance to do so.
Counsel, why was it necessary to do so? And why did it need to be raised before the trial court, given the nature of the claim that's being brought? Why was it necessary to raise these concerns with the bankruptcy court?
Well, because that's the forum that they're in front of. And if they had the concerns of whether or not it was a legitimate proceeding, or if there's any issues about how it was prepared or presented by the court, that's where they should have raised that, Your Honor. To just wait and bring it up down the road, they basically waived it. And so that's the concern. If they had the opportunity to have any concerns or whether or not it's a legitimate proceeding, they can bring that up to the court. And they had the chance to do so, and they just chose not to. They went forward, engaged in the judicial settlement conference, and reached a resolution with their former clients and took their money. They got the $350,000 and moved on. And just to note something different in the record, I believe that the case was not sought to be dismissed by the trustee, however, it was sought to be converted to a Chapter 7. And so if there's an issue regarding whether or not it was a legitimate bankruptcy, or whether or not the Wolks were interested in it or anything, and as the court kind of noted in the appellant's argument, that would have been taken up by any court, and and would have been dismissed or seriously considered by it. And so nothing was raised at the time. And so we submit that there's been a failure to basically establish the cause of actions that they've asserted. Intentional interference with business, and then also procurement or breach of contract. And as the court discussed below and in its opinion, that there's a clear statutory scheme, what the elements are for the intentional interference with contracts here in Tennessee. And it's the TrawMed versus Allstate case, that there needs to be an existing business relationship with specific third parties or prospective relationship. Secondly, that there needs to be a knowledge of the relationship and not mere awareness of it. And there's no dispute about those two issues. We're not contesting that Mr. Lefkovitz didn't know that there was some type of relationship between the parties. I'm talking about between the plaintiff's attorneys and their former clients, or that they had that there was knowledge of that relationship. The problem is the third, fourth, and fifth elements. The third one is intent to cause a breach or a termination of the relationship. Fourth, an improper motive or means, and fifth, damages. And so, as the court noted in the previous part of this argument, there's already a breach of that relationship between the Wolks, the original clients, and their counsel, the plaintiff attorneys. There's a professional relationship issue, but clearly they had already sought counsel, and there was a fracture of that relationship even before they came to see Mr. Lefkovitz. He didn't solicit them for this work. They were referred to Mr. Lefkovitz by another attorney here in town. And they came to him for assistance in resolving this dispute that they already had with their attorneys. And it was premised on the fact of how much they would have to pay under that agreement. The problem was, as I noted before, that they did a great job in that case, but only obtained equitable relief. They obtained the property back for their clients. And so therefore, there wasn't any money to be had on the table to pay the attorney's fees. So the parties... So therefore, there wasn't a breach that occurred that Mr. Lefkovitz did not cause that breach. And then secondly, improper motive or means. And so Mr. Lefkovitz met with the counsel. In fact, he tried to work it out with them before the Wolks pursued bankruptcy protection and they weren't able to do so, and they went to bankruptcy court. So clearly he was following the process of trying to resolve things and not seeking any improper means. He's actually kind of going through legal process. And then damages, the plaintiff attorneys, they had already agreed to this amount of a settlement. And so they had already agreed to compromise their claim, a significant compromise, in order to be paid that, and they were paid that by the out of the bankruptcy proceeding. And so we submit that so that there's no grounds to recover under that tort in Tennessee. And then secondly, the other thing that they sued under is procurement of breach of contract, somewhat similar elements, and the quality auto parts case, which establishes those. And we submit that there's no basis to recover under any of those elements as well. However, we note that that issue was not raised to the trial court. We briefed this issue on our summary judgment motion at the trial court level, and it wasn't argued at the trial court, and then also wasn't raised on appeal. So we believe that that actually claim was waived if it was there. But despite all this, even if there was grounds to recover under either of these tort that we talked about here today, the litigation privilege would preclude that recovery. The Unarco versus Libertado is the standard case in Tennessee on this issue, which provides that an attorney is immune from liability to third parties for words or acts arising out of their professional relationship as an attorney. And the elements that must be shown, and we established them in the trial court, went through this analysis itself, that attorney has to be acting in their capacity as counsel. There's no dispute about that. Mr. Lefkovitz was acting as counsel for the Wolks. That there must be a good faith for the benefit of the client, acting in good faith for the benefit of the client, not the own attorney's self-interest. And when I deposed Mr. Throckmorton, actually, and I put this citation in the record of his testimony in this, he conceded that there was no bad faith, that Mr. Lefkovitz wasn't acting for the benefit of himself, other than the fact that he was paid his normal professional fee. And the third element is that the conduct must be related to the subject matter of the proposed litigation. Clearly, Mr. Lefkovitz met with the plaintiff's attorneys, tried to work out a resolution, threatened to go to bankruptcy. They couldn't, and actually did file the bankruptcy action. And so clearly, there is a that the conduct is related to what was actually litigated in the case. And then fourth, that there has to be a nexus between the attorney's conduct and the litigation. And as a result, I don't think there's any dispute about what Mr. Lefkovitz was doing, was attempting to negotiate a lower amount for the Wolks on behalf of their attorney's fees payment that was due and owing, and he was successful in doing that. Now, there is a special exceptional circumstances rule that the litigation privilege doesn't apply if improper means are used, and it refers to, and the improper means are things like fraud, trespass, threats, violence, or other criminal conduct. Very specific. And all the actions taken by Mr. Lefkovitz were clearly in the course of his professional relationship, and none of them even rose even close to the level of that. There's a case that this court heard a couple of years ago named the Law Offices of Robert Hill, in which there was an attempt to destroy a law firm, kind of do a hostile takeover. And some of the things that were used in that case, and the litigation privilege was deemed to apply, were that there were some false and fraudulent allegations in some pleadings, that some of the parties participated in improper ex parte communications with the court in order to deceive the other parties, and that there was suborning of perjury in that case. And the court found that those things did not rise to the level of improper means in order to give an exception to the litigation privilege. And so certainly that egregious conduct that it's talking about, things that undermine our judicial system, like suborning perjury or filing false pleadings, certainly if that is not a case of wrongful means, then clearly this is not as well. And so based on that, even if the plaintiffs had been able to establish their ability to recover under any of the theories that they had, the litigation privilege would protect the conduct and the actions of Mr. Lefkovitz. And in the case law, the litigation privilege has been expanded generally over time to include both words and acts. And originally it was just talking about defamation and things like that, but that it's been expanded to include other conduct and even pre-litigation conduct like we're talking about here today. And so based on that, we believe that the trial court's decision should be upheld and that there's no basis for the plaintiffs to recover in this action. Thank you, Your Honors.
Thank you. Yes, sir, your rebuttal.
Thank you, Your Honors. I think the Hill case is just where I want to lead in on. In the Hill case, the trial court actually overruled the litigation privilege on some of the counts. And the trial court did that because it said they were related to wrongful means, okay? What did the trial court sustain the litigation privilege on? Things in pleadings, comments to the court. The wrongful conduct we talk about has nothing to do with it. We're talking about the shakedown that occurred in the office, the threat that I'm going to get it from you no matter what, the fact that I'm going to file a bankruptcy my clients don't even know about, the fact that I'm going to take a cash fee, not report it like I'm supposed to, can't tell the court where it came from, I don't even remember where it came from, I'm not talking about where it came from. That's the wrong type of conduct we're talking. We're talking about conduct, not publication and pleadings that might defame another lawyer or another person. Now, what the bait is, if you're not careful here, is they're asking you to overrule UNARCO. Because what they're saying is there is no limit. There is no limit to what a lawyer can do and not be protected by the litigation privilege. They even said so just a moment ago. It covers any kind of action taken by Lefkovitz. That's not what UNARCO says. UNARCO says it doesn't cover what is wrongful means. Now, quickly on litigation privilege. It has its genesis out of Missouri. UNARCO found the litigation privilege defense in Missouri law, just like Wyoming deals with corporations and Iowa does administrative law. Missouri apparently does litigation privilege. It cites two wrongful means cases in its holding, Mackey and Nazari. Looking further, there's also a case in the exceptional circumstances rule where they held, White v. McCoy, 101 Southwest 2nd at 766, attorney held liable for instituting a suit when the attorney knew his client's claim had no merit and that the suit was being instituted in bad faith for the purpose of compelling payment from the defendant. It's spot on. And that is the body of litigation privilege law. So we can distinguish Hill. They're asking you to overrule UNARCO. No further questions?
I hear none. Thank you very much.
Okay, thank you all.
I want to thank the attorneys for your presentation. Your case has now been submitted to the court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you very much, and attorneys may be excused.